first to you, Dr. Singhvi, because the big question is, every time any Congress leader, in this instance the Gandhis, are summoned by the ED, the first reaction is political vendetta. However, the charges made are very specific. The charges in this case of the manner in which Young India Limited was set up in 2010, where allegedly Sonia and Rahul Gandhi held a 76% stake, whereas 90 crore loan that had been earlier given to associate journals that owns National Herald was then left to Young India to take over with a 50 lakh investment, takes over this company, associate journal, and thereby gets control of 2,000 crores. This is the chronology. Rather than challenge the chronology, you immediately scream political vendetta. Your response? You're on mute, Dr. Singhvi. You're on mute.
The chronology, Rajdeep, the chronology is a little different and a little inconvenient to those who want to indulge in propaganda. And I'll be very pointed and brief, but this is important for your viewers to know. This is the first case I've heard of or imagined where you can have money laundering without either money or property moving 1 millimeter even. It is unheard of, and a kindergarten person will tell you, without any knowledge of law, that without either movable or immovable property moving an inch, there is money laundering. Number one, it is an old legacy National Herald for 6-7 decades. Number two, it fell on difficult times. Number three, it ran up debts over the decades of roughly 90 crores. Number four, the Congress infused this money and the debts were repaid, and this was used to pay off wages, pay gratuity, things like that. Subsequent to that, all that AGL did, which owned all the assets of National Herald, was to convert its large debt into equity. It is done by every company in India and abroad. It's a known technique that whatever debt you have, you give equity to somebody, and therefore, because that somebody has helped you, you convert your debt into equity. The somebody who helped them and who got the equity and therefore became the holding company of AGL was a company called Young India. Now, Rajdeep and I are conspiring to take over AGL, and we will go, that is Rajdeep and I, to incorporate Young India, which is a not-for-profit, special statutory vehicle, which can't pay a penny of dividend, which can't distribute profits. So we must be pretty foolish conspirators, Rajdeep and me, to have conspired to create a company which can do nothing.
But now which controls large assets? Which controls large assets? 50 lakhs is what is paid by Young India to take over AGL, and thereby it controls assets worth 2,000 crores.
Allow me to finish, Rajdeep. Serious debate requires fact. That's the problem. So I'll be very pointed, you know that.
Yes.
Now, this goes to Young India. Young India is the holding company under all established law. The assets which you call 2,000 crores remain with AGL. Not a penny moves, not one asset moves from AGL anywhere. AGL remains the owner. AGL's shareholding is now with Young India, that's all. But under corporate law, this is a separate entity which owns all the shares, but no property is moved. The same shareholders, the same property, the same money. Now, I want to ask you, in a not-for-profit company, even if it has shareholder interest in AGL, how on earth that not-for-profit company not being able to give out dividend, profit or any benefit, can't pay salary or perks to its directors? How on earth can any money laundering be imagined? Where is the movement of money, the money trail, the conversion? What is money laundering, Rajdeep? It is the conversion of unaccounted money and its projection and use as accounted money. If there is no movement of money at all, not one penny, and there is no movement of immovable property, how is the money laundering? Number three, this happened in 2014. I appeared in the case. That case is going on, the main predicate case. In 2015, the file of the parallel case of ED attempted to be started was closed. Subsequently, the ED officer was sacked. The new officer was made to reopen the file in 2015. In 2015 to 22, nothing happened. In 22 now, summons are issued. There are only summons at section 50 to both the Congress president and the former Congress president. But obviously, it is but obvious that have you ever heard of any BJP factotum or institution getting notices on such facts? Have you heard of any entity associated with the BJP, a friendly entity, being pursued by any agency on these facts? It is obviously because you want to divert attention from humongous inflation, 14% and 8% respectively. You want to divert attention from unemployment of humongous proportions. And you want to do these things in a context where money laundering, we are only concerned with this notice now. We're not talking, if I have violated, if National Herald has violated some lease, please take over the property which you initiated. If National Herald has violated the Companies Act, please take action under the ROC. Where on earth does a money laundering summons come? Only to humiliate, to create sensation, to create let me end by 1 second, 5 seconds more. Every opposing political entity to the BJP, and every journalist can put his hand on his heart and you'll find the answer. From Kashmir to Kanyakumari, from Gujarat to West Bengal, which is opposed to the BJP, is having similar episodes. But nobody in the BJP will ever have it.
No, you're making a very serious charge, which I would, with due respect, ask you to 1 minute listen to the BJP representative, because you have made a very serious charge today. No, you must, Dr. Singhvi. Do listen. In the interest, I give equal time. You must listen to it.